only some of the CLE things that the workers' compensation lawyers have done this year, but also is going to include a discussion of at least a couple of appellate court cases, a legislative update, and also at least one commission decision. Because those of you who have come to these programs have noticed that, generally speaking, those are the categories that our programs fall into, right? Once or twice a year, we always talk about legislation. More than that, 3 or 4 or 5 times a year, we talk about new appellate court cases, and I think WICLA does a really great job of staying right up to date on the new appellate court cases. And then, most recently, we've begun to talk about some commission cases, and we'll talk a little bit more about how we intend to go forward with that a little bit later in 2018. So the first slide I've given you here is the 2018 MCLE schedule. So this is a tentative schedule. It's pretty solid, but some of these dates might change depending on some other things happening. But generally speaking, what we try to do is a monthly program, alternating Tuesday, Wednesdays, and Thursdays every month. We try to do a professional responsibility program on Lincoln's birthday, and this year that's going to be Monday, February 12th, 2018. What we're going to do for that program this time is we're going to try to include those special professional responsibility credits that we now have to get. So for those of you who've been keeping up with the MCLE development, you know that you still have to get the requisite number of professional responsibility credits of your 30 hours every 2-year period. But a number of those professional responsibility hours now have to be in the area of diversity and substance abuse. So what we intend to do on February 12, 2018 is provide a 3-hour program. 1 hour is just going to be kind of standard professional responsibility stuff. The other 2 hours are going to include those special credits, the diversity and the substance abuse. So that's what we're going to try to do as a benefit to our membership so that you can satisfy the requirements of the MCLE board for those special kinds of credits right here. And of course, it's free to WICLA members. The other 2 special programs that we try to do during the course of the year are we try to do 2 3-hour special medical legal programs. We've started doing one in the spring, and we're going to continue to try to do that on Wednesday, April 25th, 2018, and that's going to be in conjunction with the Workers' Compensation Commission judicial training so that arbitrators and commissioners who are in town for that can attend that program as well. And then, of course, for many years we've done the traditional fall program in September. We intend to do that again, 3 hours of medical legal credit. And we don't know the exact date on that yet, but it's going to be sometime in September of 2018. And again, we're going to try to interface with the Workers' Compensation Commission so that we do it during their fall judicial training and make sure that any arbitrators or commissioners who want to attend that program can. So this is the kind of tentative schedule for 2018. It's pretty firm, but there may be some dates that need to change one way or another. As you all, I hope, know by now, in 2017, WICLA applied to provide these credits through the internet. So since October of 2017, WICLA members have been able to watch these programs online, so to speak, and get credit for it. We've made it such that when a program takes place, the recording of the program will be airing for the next month, and you can watch it during that 1 month period for credit. So for example, in the program that took place in October of 2017, you were able to watch that program from November 1 until November 30th for credit, and we're going to continue to do it that way. So the program will happen in October, it will be available in November, and so on and so forth. So far as we've been able to determine, about 50 of our members have taken advantage of watching the October and November programs. So if any of you are having problems with the mechanics of actually getting to the website to call up the program and get your certificate of attendance afterwards, please just let me know. Not because I can do anything about it, but I'll forward it on to our administrator and let her deal with it, okay? So has anybody here in the room done that yet? Has anybody taken advantage of that yet? No? Oh, great. How was it?
It's great, except I haven't got my certificate yet.
Okay, well, so that's the complaint that we've actually had from about half of the 50 people who have watched it. So we're still trying to work out the bugs on that. Bear with us. If you've watched the program and you can't somehow get the certificate, just email me. And if you certify to me and attest to me that you've actually watched the program, I'll send you a certificate personally until we can get the bugs worked out, okay? So I'm glad that you liked it. I'm sorry that there was a little bit of a bug. We're going to try and work those things out. So,
hey Dave,
yes?
one other thing. Pat and I tried it just to see if we could do it, even though we attended the seminar here. Once we got to the part where you had to copy and paste the link to get the certificate, we lost that link, and then we couldn't get back in because we couldn't do the survey again because it kicked us out and said we already did the survey. So,
okay, so another bug, I'll make sure that our administrator knows about that so that we can correct those things. Bear with us, WICLA has only recently moved into the 21st century like the rest of you, so we're trying to work it out. But again, if it's just a matter of not being able to access the certificate, just email me and I'll send you, one of the hard copy certificates that you get here at the program when you attend personally. Any other comments about that or complaints about the online? Yes?
Yeah, first of all, thank you for all the hard work you've done, and Francis and all the other people. I haven't watched one for credit. Some of the ones I tried to watch without credit or available. Some of the audio can be difficult to hear.
Okay. So I'm going to let our expert cameraman, Francis O'Byrne, deal with the audio issues. So Francis?
We have a new microphone that I bought that it's installed on top, so it should pick it up.
All right, so hopefully we've got a little bit better audio. And if we continue to have a problem, we'll maybe figure out some way to link it right into this microphone somehow.
Yeah, I could do that too. We can get a Bluetooth.
Okay, well, see, we could have done that already, I suppose. All right, well, thanks. So thanks for all the comments and compliments. WICLA really does appreciate it. Over the course of a year, we provide over 3,000 lawyer hours of MCLE, and it's all free. So I think we do a pretty decent job at that. So as Jack told you earlier, I'm going to make the same plea to you. Okay, all of you, I'm preaching to the choir, right? All of you are members, and you're all here. So thanks for continuing to be members of WICLA. But let your colleagues know that maybe there's something good going on here, and maybe they want to get involved. For the membership fee of, what is it, $200, okay, you can get 21 free hours of MCLE, okay, on the subject that you care about, right? Not about how to do a closing or how to do a divorce or anything else, right? The subject that you care about and need to know about. 21 free hours a year for a membership fee of $200, okay? So make sure your colleagues know about what's going on at WICLA. All right, great, thanks. So let's move into the legislative update, right? So we talked about this earlier in the year, but we're going to review it and talk about it again now. So this slide represents kind of what was going on in Illinois during the period of time that our legislators were debating whether to make some changes to the Workers' Compensation Act. So this slide is titled NCCI data. For those of you who don't know, NCCI is the National Council on Compensation Insurance, and it's the official rate-making organization for the state of Illinois. So this is the organization that sets the insurance rates for workers' compensation insurance. What's an insurance rate? So for example, an insurance rate might be $2.47 per $100 of payroll for a certain employment category. It might be maybe roofing, although it would probably be much higher than that for a roofer. So $2.47 per $100 of payroll, and that's how an employer gets charged a premium, right? If their payroll is $100,000, you multiply that rate by 1,000, and that's their workers' compensation premium. There's modifiers and everything else, and so that's a little bit of a simplification. But the fact of the matter is the rate determines, how, at least in part, what the premium is. So NCCI every year is required by the Department of Insurance to come up with a recommendation about what the rate should be for the next year. And this is the historical data for what NCCI has recommended since the amendments to the Act back in 2011. So immediately upon those amendments becoming effective, NCCI was required by the legislation at that time to make a change or to make an adjustment in the rate, and the immediate rate adjustment at that time back in 2011 was to reduce the rates by 8.8%. And you can see what has happened every year since then, except 2012 when there was a bit of an increase. Every year since then, the rates have come down, sometimes by very, very large amounts. You look at 2017 and 2018, you've got double-digit reductions in the rates, and in fact, in 2017 and 2018, depending on how you're actually looking at the numbers, the Illinois rate reduction was either the second or third largest rate reduction of all the states in the United States. All right? You add them all up, and the rate reductions that NCCI has recommended since 2011, in excess of 42% rate reduction. So everything else being equal, an employer in the state of Illinois who has the same payroll that they had previously, who had the same experience that they had previously, no accidents occurring or one accident a year or whatever it is, theoretically at least, that employer should be paying 42% or more less than what they were paying in 2011 for their workers' compensation premiums if all they were doing was following these NCCI rate recommendations. And you can see that those rate recommendations were based on actual loss costs coming down, because what NCCI does is every year report what the reduction is or increase is in the loss costs. And again, other than 2012, since 2011, there's been an actual reduction in loss costs added all together over 36%. So I give you this slide just, and I've shown it to you before, just because it's important to understand the context in which some of these legislative changes were being suggested. So the first bill that passed the General Assembly in 2017 was House Bill 2622. And what this bill did was to create what's called the state fund. And what the state fund is a state chartered insurance company, a not-for-profit state chartered workers' compensation insurance company that was going to theoretically compete with the for-profit insurance companies. It passed both houses in May of 2017, as you can see, by relatively narrow margins, and these margins represent pretty much partisan divisions, right? So of those votes that were given to pass the legislation, the majority, if not all of them, I think, except maybe in one occasion, were Democrats, and the votes against the bill were Republicans. As I've already said, what it did was create this Illinois Employers Mutual Insurance Company, which was supposed to be a not-for-profit workers' compensation insurance company. It was going to be administered by a board of directors that was going to be appointed by the governor. That board was going to set those rates that we've already talked about, so I suppose they could use the NCCI data or they could use whatever rates they decided to use, but the board was directed in the legislation to set the rates. The way the state fund was initially going to be funded, because it had yet to collect any premiums, was from a $10 million loan from the Workers' Compensation Commission Operating Fund. So the way it was supposed to happen was that there was supposed to be a loan from the commission to the state fund. As the state fund collected premiums, it would pay back the loan. So, bill passes both houses of the Illinois General Assembly, and Governor Rauner vetoed the bill. And he totally vetoed it. So, as we talked about, when we talked about the legislative, the legislative history in Illinois, we talked about the difference between total veto and a mandatory veto. In this particular case, Governor Rauner chose to totally veto House Bill 2622. He had a choice, I suppose, to mandatorily veto it, to say, look, I don't like the funding mechanism, so I'm going to change that. Or I don't think that it should be $10 million, maybe it should only be $5 million to start, or maybe the board of directors should be bigger than what it is, or smaller than what it is, or have less authority than what it does, or whatever. Governor Rauner chose not to mandatorily veto this bill. He totally vetoed the bill. And this is his rationale. It comes directly from his veto message. As you can see, what Governor Rauner was concerned about when he vetoed this bill was disrupting the competitive market of Illinois workers' compensation insurance companies, which is composed of over 320 insurance companies that are writing workers' compensation business in Illinois. Illinois is the largest state for the number of insurance companies writing business in Illinois, even though we're not the largest state in terms of premium or anything like that. In terms of the number of companies actually writing business in Illinois, Illinois is the largest business state. Governor Rauner was concerned about disrupting that free market competition, and there was also some concern that the governor had about the $10 million loan from the Workers' Compensation Commission to the fund. So that was the basis of Governor Rauner's veto. Speaker Madigan responded to Governor Rauner's veto, and this is Speaker Madigan's response. Speaker Madigan's response to Governor Rauner's veto was that he saw it fundamentally differently than Governor Rauner, right? What Speaker Madigan thought was that the more competition for insurance business, the better. And Speaker Madigan thought that if there was a workers' compensation problem in Illinois, it was an insurance problem and not a workers' compensation problem. And you can see that kind of embodied here in Speaker Madigan's response to Governor Rauner's veto. So, as a result of this response, the sponsor of the bill in the House filed a motion to attempt to override Governor Rauner's veto, which motion would have required a 3/5 vote of the 118 members in the House, 71 members. And as you can see, on October 25th, 2017, that motion to override the veto of Governor Rauner fell short by 6 votes. 65 votes in favor of the motion to override the veto, 50 votes against. Again, strictly broken down on partisan lines, all Democrats voting for the motion to override, all Republicans voting against. Where does that leave House Bill 2622 and the state fund? Dead is where it leaves it, right? Once the motion to override fails, the veto stands and the bill is dead. Does it mean that the bill can't be reintroduced next year? No, it doesn't. It can be reintroduced. Perhaps some of the suggestions that Governor Rauner has made in his veto message will be incorporated into whatever new version of that bill is proposed, although I haven't seen anything like that being filed yet. So, House Bill 2525 was the other bill that passed both houses of the General Assembly last year. And again, you can see that that happened in late May of 2017. Again, the votes strictly on partisan lines, all Democrats providing the yes votes, all Republicans providing the no votes. But House Bill 2525 was a little bit different from House Bill 2622 to the extent that it wasn't just one subject, right? It was kind of an omnibus workers' compensation reform bill. So there were some provisions in that bill that had to do with insurance rate regulation, which, as we saw, Speaker Madigan is very concerned about, okay? Including things like making companies pre-file their rates, giving the Department of Insurance the authority to determine when premiums are excessive. There were some statutory definitions in this bill about things like in the course of and arising out of, which seemed to mimic language out of certain cases like CISPRO. There was some language in this bill defining what a traveling employee was and how the coverage for a traveling employee worked. It seemed that some of that language came out of the Venture-Newberg case, which we've talked about before. There were premium discounts for employers who adopted safety and return to work programs. There was a repeal of the Will County Forest Preserve case, right? The case that says the arm, or I'm sorry, the shoulder, I was going to say the arm is not the arm. The shoulder is not the arm, right? It's the man as a whole. So there was a repeal of that and also a clarification that the hip would in fact be the leg and not the man as a whole. There was a provision here for contribution from previous employers for repetitive trauma injuries. There was a provision that adopted the ruling in Corn Belt, which, as we know, says that there does not have to be an ANA impairment rating in every case in order for there to be a permanent partial disability award. There were some procedural things in this bill, including the abolition of that 2-year arbitrator rotation, which we're all struggling with right now, beginning in January of 2018, right? Who's on first? You know, who's my arbitrator now in Geneva? Who's my arbitrator in Peoria or Bloomington, right? The arbitrator Granada being here. So, you know, we're all struggling with that 2-year rotation, and this bill would have abolished the 2-year rotation. There were some other things in the bill that you can look through here. One of the most interesting things in this bill was that for the first time there was going to be a credit for man as a whole as it related only to back injuries, right? So for back injuries, there was going to be credit for man as a whole against other back injuries as long as it was the same part of the back, you know, the upper back or the lower back, but there was a credit for man as a whole in this particular bill. Once again, Governor Rauner totally vetoed this bill, House Bill 2525, so he didn't pick out certain parts that he said he liked, like the man as a whole credit or the repeal of Will County Forest Preserve or anything else. He just said, I'm repealing the whole thing. And again, part of the rationale for that was that it would disrupt the insurance market in Illinois, which is, according to Governor Rauner, seems to be working pretty well because there are so many companies and they're all competing vigorously, you know, to bring premiums down or whatever. So in this particular case, since the House had already seen that they couldn't override the veto on 2622, there was no motion even filed to override the veto in this particular case, and the bill died. So once again, this bill is dead. I haven't seen any reiteration of this bill already filed for the 2018 session, but this bill, at least as it existed then, is dead. Yes, sir?
What's ASTC?
Ambulatory Surgical Treatment Center. So apparently there's still some controversy, which is way above my head, about how ASTC's bill for their facility charge, and this provision in the bill was going to somehow clarify that, or rectify that, or change that, or something, but really it's way above my head to understand exactly what the problem was or how this was going to fix the problem. Suffice it to say that apparently there's a problem that needs fixing. So, all right. So, any questions about the legislative update? Any comments about the legislative update? Okay, good. All right. So, let's move on to the second thing that WIPLA always tries to do, right? We try to keep you up to date on the most recent appellate court decisions, right? Thank you. So we try to keep you up to date on the most recent appellate court decisions, and I'd like to just go over a few of those now, ones that seem to have been important. And the reason why I picked the Terry Noonan case, which we've already talked about here, is because it has to do with this idea of neutral risk, right? If 2017 was anything, it might be called the year of neutral risk, right? Because how many cases did we talk about here, and that had been decided in 2017 that show us how the appellate court is struggling with this idea of how to deal with what's called neutral risk. So Terry Noonan was a petitioner who was sitting in his chair at work for the city of Chicago. He dropped a pen on the floor, and as he reached over to pick up that pen that he had dropped on the floor, the chair that he was sitting in maybe scooted back a little bit, and he felt immediate pain in his back and testified that he had injured his back. So in this case, the respondent paid temporary total disability benefits and medical benefits while the case was going on. But when the case got tried before the arbitrator, the claim was denied. Okay? And the claim was denied by the arbitrator because there was no testimony, as you can see in the slide, that the chair was defective in any way, that the petitioner was somehow in any hurry to pick up the pen, although I don't know why you wouldn't be in a hurry to pick up a pen that you've dropped. I mean, what's the point in delaying picking up a pen? But in any event, what the arbitrator said was that the petitioner failed to prove that sitting in a chair and bending over to pick up a pen exposed that worker to any risk greater than the general public, right? This neutral risk theory, right, that we all hear about. And in this particular case, the petitioner didn't prove that that neutral risk had somehow transmogrified into an employment-related risk, and we'll talk about maybe how that happens. But in this case, it was strictly a neutral risk, and therefore compensation was denied. So the commission affirms and adopts that decision from the arbitrator, and the circuit court reverses and remands it to the commission. So on remand, once again, there is a discussion by the commission regarding this neutral risk theory and how the petitioner didn't prove that the neutral risk had somehow converted itself into an employment risk, either through this qualitative analysis or quantitative analysis that we've talked about before and are going to talk about again, I'm sure. So petitioner appeals the case to the appellate court, and the first issue the appellate court addresses is this procedural issue about what the commission is supposed to do on remand. So if you're interested in the procedural issue, about what happens when the circuit court remands a case to the commission and what authority the commission has to write a different kind of award or decision than what it previously did, here's a good case to take a look at and see what the appellate court says, which basically can be summed up in this. The appellate court says to the commission, look, do what the circuit court tells you to do, right? I mean, it's a pretty simple and maybe even, stern instruction to the commission. Do what the circuit court tells you to do. But in any event, the appellate court went on to address this neutral risk idea, and the appellate court says in this particular case that it agrees with the commission that the petitioner didn't prove anything special about this chair or bending over, either in terms of a quantitative way or a qualitative way, that he had to do this more than members of the general public have to pick up a pen that has fallen to the floor, or that somehow, the risk of bending over was quantitatively connected to his employment, and therefore it was a neutral risk and therefore was not covered under workers' compensation. So this is one of a handful of cases that the appellate court decided in 2017 involving neutral risk, including a pretty recent case called Dukich, which I'm sure some of you have already seen, which we're going to save for the January 2018 program, right? Because it's a really important case, and we're going to talk about it. So if your curiosity has been piqued even just a little bit by that, be here in January, because we're going to be talking about Dukich then. Okay? It wasn't all bad news in terms of neutral risk for petitioners in 2017 from the appellate court. This is a slide that you don't have in your written materials, so don't look for it. I snuck this one in on you. Okay? But here's a case called Mitnick, right, which we talked about here earlier in the year, which says that sometimes bending over to pick something up is an employment-related risk, right? And those are the facts in Mitnick, right? Mitnick worked for Ford on the assembly line, and his job was to put bolts into a part that passed him on the assembly line. On one particular occasion, one of these bolts fell onto the ground, and Mitnick bent over to pick up the bolt, much like Noonan bent over to pick up his pen in the previous case, and injured his back. But in this case, the appellate court said that that was not a neutral risk, right? The act of bending over in Mitnick to pick up a bolt was not a neutral risk, whereas the act of bending over in Noonan to pick up a pen was a neutral risk. Now, you can read Mitnick again for yourself and see if you can make the distinction between bending over to pick up a pen and bending over to pick up a bolt. At the end of the day, the distinction really is that the commission found in Mitnick that it was a compensable case, right? And when the appellate court is dealing with it on a manifest weight issue, right, they're giving deference to the commission decision. So in this case, the commission found that the reason why this was a compensable risk as opposed to strictly a neutral risk was that it happened a lot, right? The bolts falling off the assembly line down onto the floor happened a lot, so there was that qualitative analysis, right? And there was the quantitative analysis too, which is that the petitioner in this case said, look, if I don't pick up that bolt and it slips into the assembly line, it can jam up the machinery and the whole assembly line has to shut down because of that one bolt. So I've got to go down there and get that in a hurry, right? And that's that quantitative or qualitative analysis then converted it into an employment risk. I suppose Noonan might have said the same thing, right? Look, if I don't pick up that pen, I don't have anything else to write with, although that would have been maybe absurd, right? Although, why couldn't he have said, look, if I don't pick up that pen and one of my co-workers walks by and slips and falls on that pen, right, that co-worker now's got a workers' compensation case even though I didn't when I bent down to pick it up, all right? So I suppose there could have been some qualitative type of analysis in Newman, but the appellate court wasn't buying it and admitting it they were. Okay? So, the reason why I bring up these two cases is not only because we've talked about them before, but it just goes to show you how the commission and the appellate court is struggling with this whole neutral risk theory, right? As we are, right? We're looking to the commission and we're looking to the appellate court for guidance, and we're getting maybe some mixed signals. All right, that's why it's important to be here in January when we talk about DuPage, okay? Because maybe there's no mixed signals in that case. All right? Okay. So, any questions about neutral risk? Any comments about that? Any? Okay. Neutral risk was a big issue in 2017. All right. The Carl Crittenden case was a big issue in 2017 too. And the reason why I know that is because I have heard that this case was the subject of a lot of discussion at the fall 2017 judicial training for the arbitrators and commissioners. So let's talk about Crittenden and what it says and what it stands for. So here are the facts of Crittenden. You've got a petitioner who can't go back to his old job for the city of Chicago. There's some dispute between the vocational experts about what type of job he could get and how much that job would pay. So Crittenden decides that he's going to try his case on a wage differential theory, right? And so when he tries his case on a wage differential theory, what he has to do is establish by evidence what his post-injury earnings would be, right? Because that's part of the formula for a wage differential. And in this case, what Crittenden was able to prove with the arbitrator was that there was a range of jobs that he could do paying from, a low amount to a high amount. And what the arbitrator decided to do in this case was to take the average of those jobs, right? The average of the low and the high, and determine that that was the post-injury earnings for workers' compensation purposes, for wage differential purposes. The commission disagreed, right? The commission said, look, we have reason to believe, and we have a suspicion from looking at the record that maybe Crittenden wasn't being as cooperative as he could have been with vocational rehabilitation, and therefore we're going to set that post-injury earnings at a lower rate than what the arbitrator had, right? So everybody understand that the commission reduced the post-injury earnings, which, increased the post-injury earnings, right? Increased the post-injury earnings, which then reduced the petitioner's wage differential, right? Did everybody understand that? I screwed it up the first time, right? Everybody understand that? And the reason being is that because the petitioner wasn't being fully cooperative with vocational rehabilitation. So the commission said, therefore, as they didn't really use the word punishment or penalty, but clearly there was a little bit of something like that involved in this decision. The problem is that higher earning level was tagged to a truck driver job, which Mr. Crittenden could not do because he didn't have a driver's license. And he was never going to get his driver's license back for reasons that are not subject to this discussion, right? So he had lost his driver's license and he wouldn't get his driver's license back, right? And yet the commission based that higher earning level on a truck driving job. And so what the appellate court says in Crittenden is you can't do that, right? You can't just pick a number because you like the number, right? What you've got to do is you've got to pick the suitable employment first, right? So it's the reverse analysis from what the commission did. First, you've got to look at what the suitable post-injury employment would be, and then you determine what that job pays, and that's what is used to calculate the wage differential, right? It's not the other way around. It's not saying, we like that wage, and let's see, oh yeah, here it matches up to this job, right? And that's how we come to the conclusion, right? The appellate court is telling us that the first thing you got to do is you've got to identify the suitable employment, and determine what that job pays, right? And on the basis of that, what the appellate court did in Crittenden is send the wage differential calculation back to the commission. And I have it on good authority from the petitioner's lawyer this morning that that recalculation is currently before the commission, right? So the commission has been told by the appellate court how this is supposed to occur. You're supposed to identify the suitable employment first, determine what that pays, and then that's the basis for the calculation of the wage differential, as opposed to just picking a number and then somehow seeing if there's some evidence in the record to support that number. Okay? All right. Any questions about this one? It apparently was a bit of a controversial decision, and I understand that it engendered a lot of discussion among the arbitrators and commissioners about how you actually calculate these wage differential claims. All right? Anybody have any comment or concern about that one? All right. So then let's, this is my last slide, so maybe I'm going to have to stretch it a little bit, right? So this is Melanie Martin. So why do I have this case here? This is a commission decision. Okay, so we've talked about the legislative update. We've talked about some recent appellate court cases. We've talked about, now we're going to talk about a commission decision. So once or twice a year, what we'll do in this program here at noontime is we will take a look at some interesting recent commission decisions. And this was one of the cases we looked at. In addition, though, as I'm sure some of you have already seen, late in 2017, what WICLA started doing was actually sending a commission decision synopsis out to our members, right? Has everybody gotten that? Right? How do you like that? It's pretty good, isn't it? Right? And so what we're going to continue to do that too. So not only is WICLA keeping you up to date on legislative matters, we're keeping you up to date on appellate court decisions, we're keeping you up to date on commission decisions, okay? Every month you're going to give one of those commission decision kind of summaries from us, and then every couple of months or every 3 months or so we'll come here and we'll talk about some of those cases, okay? So another reason to encourage your colleagues to join WICLA. So the reason why I picked the Melanie Martin case to review, because we talked about it before, was because it's that neutral risk theory again, right? I told you 2017 was the year of neutral risk. This is another neutral risk case. It's a real common case that we all deal with, both from the petitioner side and the respondent side, which is fall down the stairs, right? How many of you have handled a fall down the stairs cases, right? You don't need to, because I know every single one of you has, right? We all have handled fall down the staircases, right? They sometimes get a little thornier than what they first appeared, right? Client comes into my office and says, I fell down the stairs at work, and I say, cha-ching, right? Maybe it's not that simple, right? Maybe it's not that simple, and you know, Noonan and Mitnick tell us it's not that simple. A case like Melanie Martin tells us it's not that simple. Okay, so here's the Melanie Martin case, right? Melanie Martin works for AT&T. She's leaving work on a particular night, and she remembers, oh my gosh, still on AT&T premises, right? She remembers, oh my gosh, I forgot my cell phone. She turns around to go back up the stairs to get her cell phone, right? Falls down the stairs, right? She had already signed out of work, right? She had already walked down most of that stairway to leave the premises, and she was just about out the door when she realized that it was her cell phone that she forgot, turned around, and fell. She wasn't carrying anything, certainly wasn't carrying anything work related. She wasn't necessarily hurrying, you know, like we sometimes think about. In any event, she, you know, pursued her workers' compensation claim, and she lost. Right? So she loses her workers' compensation case both in front of the arbitrator and in front of the commission and in front of the circuit court. So here were the findings that the arbitrator made and that were affirmed by the commission. So she testifies that the stairway that she was on, that she fell on, is not accessible to the general public, right? So these are AT&T premises. The stairway is not the general public. She was never instructed by her employer not to use the elevator, right? So she had the alternative of either using the stairs or the elevator, and apparently that's significant to the commission in finding that this is not a compensable case because she had a choice. She could have either used the stairs or she could have used the elevator. And I suppose if she had been injured in the elevator, if the elevator had dropped, I suppose the commission would have found, but she could have used the stairs, okay? So there was this idea that she had a choice, okay, and that was somehow significant. She chose which way to leave the premises on that particular day. She did present evidence that there was a bit of one of those like no skid strips on the stairs, but what the arbitrator found was that strip was not defective in any way. It wasn't really that big a thing, and that it was, not really any different than anything else in the area. So the commission found that it wasn't the strip on the stairway that caused her to fall. So on that basis, what the arbitrator and commission and circuit court decided was that Ms. Martin did not have a compensable workers' compensation case, right? And I suppose it's on that neutral risk theory, right? Because there was certainly no evidence about it being a personal risk, right? There was no evidence that she had previously had fainting spells or epileptic seizures or anything like that, right? So it's got to be this idea of a neutral risk, that stairs, that going up and down stairs are a neutral risk. I don't necessarily understand from reading the decision, and you guys can read it too and figure it out for yourselves. I don't necessarily understand if the fact that she was leaving maybe, was an in the course of element or something, but we all know that there's this line of cases that say you kind of get this little zone of safety, before and after work in order to leave the premises. And I don't know if it was necessarily significant to the in the course of part that it was her personal cell phone, right? If she had forgotten like some work paperwork that she needed the next morning or something, and that's what she remembered to go back up the stairs to get, would that somehow have changed the outcome of the case? Maybe, but wouldn't that be an in the course of thing instead of an arising out of thing? I don't know. But in any event, those are some of the issues that we struggle with when we look at these stairway cases. So this case, we may be talking about at some point in the future, right? Because the circuit court confirmed the commission denial of benefits, but this petitioner didn't stop. She's filed a notice of appeal in the appellate court, and the case is now pending before the appellate court. So I don't know exactly, it was just filed over the summer, so I don't even know if there's a briefing schedule or anything yet on this case, but we may be talking about this case in 2018 as an appellate court decision or 2019 as an appellate court decision. All right? So that's all I have. I suppose we're not all that short, so Merry Christmas. I'll give you 8 minutes. So, yeah, go ahead. Well, maybe I'll give you 7 minutes. Go ahead. So Mr. Tardino's question is, how does the choice matter, right? Why does it matter whether you took the stairs or took the elevator? Well, I don't know. And being a petitioner's lawyer, I would say, of course, there is no distinction. I'm sure that the commission had some reason for making that determination. But don't forget, we also looked at another case earlier this year, and I don't remember the name of the case. City of Springfield, right? Where she says on my coffee break, I'm going to go out the door to Starbucks to get my coffee. And what the commission said in that case was, right, well, she had two choices in that case. First of all, how to exit the building to go and get Starbucks, right? And secondly, her choice was not to get Starbucks at all because they serve coffee on the premises. So this idea of the petitioner choosing to do something seems to be gaining a little momentum with the commission, because those are at least two cases that we talked about in 2017 where this idea of personal choice came into play. All right, okay, thanks everybody. Happy holidays.